Every single day, the average American generates about 1.7 megabytes of data every single second. That is not per hour. That is per second. And the companies collecting that data are legally allowed to do things with it that would genuinely shock most people if they ever stopped to read what they agreed to. Welcome to Legal Eagle Brief. In the next 10 minutes, you are going to find out exactly what companies can legally do with your personal data, why the laws governing this are weaker than most people assume, and the one loophole that virtually every major tech company exploits right now, completely within the bounds of existing law. Most people think privacy policies exist to protect them. The truth is almost the exact opposite. Stay with us, because this is going to change how you think about every app you have ever downloaded. Let us start with some background. Data privacy as a legal concept is surprisingly young. Before the internet, your personal information was scattered across paper records, medical files, tax documents, credit reports. The government passed narrow laws to protect specific categories. The Fair Credit Reporting Act came in 1970. The Privacy Act of 1974 followed, covering federal government records. The Health Insurance Portability and Accountability Act, or HIPAA, arrived in 1996 specifically for medical information. Each of these laws protected one slice of your life. But nobody anticipated what the internet would become. By the early 2000s, companies were collecting behavioral data at a scale nobody had ever imagined. Your clicks, your searches, your location, your purchase history, your browsing patterns, all of it flowing into servers that could store virtually unlimited information for virtually unlimited time. Congress never passed a comprehensive federal privacy law to address this. That absence is not an accident. It is the legal foundation that lets modern data collection operate the way it does today. Instead of one national privacy law, the United States operates on what legal scholars call a sectoral approach. You get HIPAA for health data. You get the Children's Online Privacy Protection Act, known as COPPA, for children under 13. You get the Gramm-Leach-Bliley Act for financial data. But for the overwhelming majority of data collected about ordinary adults on ordinary websites and applications, there is no comprehensive federal protection. Companies are largely free to collect, store, analyze, share, and sell that data under a simple framework, notice and consent. They tell you what they are doing in the privacy policy. You click agree. That is it. Legally, you consented. But here is what nobody talks about. That consent model was designed in an era before machine learning made it possible to take completely anonymous-looking data and reverse engineer it back to a specific individual. Researchers at MIT demonstrated that just 4 pieces of location data, were enough to uniquely identify 95% of individuals in a dataset. 4. Think about what your phone generates every hour. Now let us get into the main content. What can companies actually do with your data right now, legally, in most states? The answer is more than most people realize. They can collect it without telling you in real time, as long as the disclosure is buried somewhere in the privacy policy. They can sell it to third-party data brokers. Data brokers are companies whose entire business model is aggregating and reselling personal information. There are currently over 4,000 data brokers operating in the United States. Their combined annual revenue exceeds $200 billion. They know your name, address, phone number, estimated income, political affiliation, purchasing behavior, health interests inferred from your browsing, and in many cases your physical movements throughout the day. And you almost certainly never directly interacted with a single one of them. Companies can also share your data with affiliated entities. If a company sells a subsidiary or gets acquired, your data transfers with the deal as a business asset. That app you downloaded in 2015 that no longer exists? That company sold its user database before shutting down. The buyers of that database have legal possession of your information. The privacy policy you agreed to in 2015 likely permitted exactly that outcome. Now let us talk about what companies cannot do, because this is equally important. Under current law, certain categories of information receive heightened protection. Medical records covered by HIPAA cannot be disclosed without patient authorization except in specific circumstances. Financial records under Gramm-Leach-Bliley require notice and an opportunity to opt out before being shared with non-affiliated third parties. Children's data under COPPA requires verifiable parental consent before collection. And increasingly, state laws are filling in where federal law has left gaps. California leads the country with the California Consumer Privacy Act, the CCPA, and its stronger successor, the California Privacy Rights Act, the CPRA. Under California law, consumers have the right to know what personal information is collected, the right to delete it, the right to opt out of its sale, and the right to non-discrimination for exercising those rights. Virginia, Colorado, Connecticut, Texas, and more than a dozen other states have now passed similar comprehensive privacy legislation. These are real rights, but they come with real limitations. The burden is almost always on the consumer to exercise them. And most people never do. Here is a pattern that tells you everything you need to know about how these laws function in practice. When the CCPA first went into effect in January 2020, researchers estimated that fewer than 3% of California consumers actively exercised their data rights in the first year. The architecture of the system assumes you will engage. Almost nobody does. Companies know this. Their compliance infrastructure is designed around that reality. Let us go deeper. The most sophisticated privacy issue right now is not data collection itself, it is data inference. Companies are not just storing what you tell them. They are building predictive models that generate new information about you that you never disclosed. Your insurance company might not have access to your medical records. But if they have your grocery store purchase history and your fitness app data, algorithms can infer your health status with alarming accuracy. Is that inference protected by HIPAA? No. Because you never told the company you had a health condition. The algorithm guessed. And under current law, that guess belongs to them. This is the loophole that drives the modern data economy. Inferred and derived data information the company generated about you rather than collected from you largely falls outside the protective frameworks designed for disclosed personal information. The European Union's General Data Protection Regulation, the GDPR, treats inferred data as personal data subject to full protection. The United States does not have an equivalent standard at the federal level. That gap is worth billions of dollars annually to the companies that exploit it. Now for the real-world implications. If you are a consumer, the most actionable thing you can do right now is visit the websites of the data brokers who hold your information and submit opt-out requests. California law requires brokers to honor those requests for California residents. Many brokers have extended that process nationally. It is tedious. It is time-consuming. But it is legally effective. Services exist that automate this process for a subscription fee if you prefer. If you are a business collecting consumer data, pay attention to this. State privacy laws are converging rapidly. The patchwork of 50 different state approaches is pushing Congress toward eventually passing a federal standard. The American Data Privacy and Protection Act has been debated in the House but has not yet passed. When a federal law does arrive, and most experts believe it is a matter of when, not if, the companies that have already built GDPR-compliant data infrastructure will face the smoothest transition. Companies that have relied on the weakest legal minimum will face the steepest compliance costs. The broader lesson here is that privacy law in the United States is in the middle of a generational transformation. The old assumption that your data is yours only until you click agree is being challenged in courts, in state legislatures, and in public opinion. The companies that built empires on that assumption are spending enormous resources to shape what comes next. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.